I was sitting in my home office on a Tuesday morning when I heard the unmistakable rumble of heavy machinery outside, and my first thought was that the city must be doing some road work on our street in suburban Phoenix, Arizona. What I did not expect was to look out my window and see three landscaping trucks parked directly in front of my house, with workers already unloading pallets of stone and bags of soil. I rushed outside, still in my pajama pants and a faded collared shirt, to find out what was happening on my property without my knowledge or permission. A stocky man in a yellow safety vest looked up from his clipboard as I approached. "Morning," he said casually, as if this were the most normal thing in the world. "What's going on here?" I asked, gesturing to the organized chaos that had erupted on my front lawn. "HOA approved landscaping project," he replied, checking his paperwork. "We're installing a decorative median along the street here. Should take about 3 days." I felt my stomach drop. A median? Where exactly? He walked me over to the edge of my property, where small orange flags had been placed in a line. The flags ran directly across the bottom of my driveway, creating a barrier between the street and my garage. My brain struggled to process what I was seeing. "That's my driveway," I said, my voice rising slightly. "You can't block my driveway." The worker shrugged apologetically. "I'm just doing what the work order says, man. You'll have to take it up with your HOA." We were hired by them, and they approved the plans. I pulled out my phone and immediately called the HOA office. A cheerful recorded message informed me that office hours were from 9 to 4 on weekdays, and it was currently 8:15. I left a message, trying to keep my voice level and professional, explaining that there was some kind of mistake and requesting an immediate callback. By 9:30, when I still had not heard back, the landscaping crew had already dug a shallow trench across my driveway entrance. Chunks of my asphalt lay in a pile to the side. I called again. This time a woman answered. "Sunset Ridge HOA, this is Brenda speaking." "Yes, hi. My name is Christopher Quinn. I live at 4782 Saguaro Drive, and there's a landscaping crew literally blocking my driveway right now. They said the HOA approved this, but there has to be some mistake." "Let me check our records," Brenda said, and I heard the clicking of a keyboard. "Oh yes, the median installation project. That was approved at last month's board meeting." "But it's blocking my driveway," I repeated, slower this time. "I won't be able to get my car in or out." "The project was properly approved by the board, Mr. Quinn. If you have concerns, you can submit them in writing to be addressed at next month's meeting." "Next month? I need to use my driveway today, like, right now." "I'm sorry, but the board has already made their decision. The landscaping will improve property values for the entire community." I felt heat rising in my face. "Can I speak to someone on the board? The president, maybe?" Mrs. Patricia Whitmore is the HOA president. "She's not in the office today, but I can pass along a message. Please have her call me immediately. This is an emergency." Brenda assured me she would relay the message, though her tone suggested she did not share my sense of urgency. I hung up and stared at the workers, who were now laying down landscaping fabric in the trench they had created. My car was currently parked in the garage, and I had a client meeting across town at 2 o'clock. The reality of my situation was becoming clearer and more infuriating by the minute. I decided to do some research. Back inside, I pulled up my copy of the HOA bylaws and covenants that I had received when I purchased the house 3 years ago. I had read through them once back then, but like most homeowners, I had not memorized every detail. I searched for anything related to driveways, property access, or landscaping modifications. What I found was interesting. According to the bylaws, the HOA did have authority over common areas and could make improvements deemed beneficial to the community. However, there was also clear language stating that homeowners must have reasonable access to their properties at all times. Blocking a driveway seemed like a pretty obvious violation of that principle. I took screenshots of the relevant sections and sent an email to the HOA office, copying what I assumed was the board's general email address. I outlined my concerns professionally and cited the specific bylaw sections I believed were being violated. I requested that the project be halted immediately until an accommodation could be made for my driveway access. By noon, the median was taking shape. River rocks and decorative grasses created an attractive barrier that ran the length of the street, improving the neighborhood's curb appeal significantly. It was actually quite beautiful, which made me even more frustrated. The workers had been friendly and professional, and I did not blame them for any of this. But the fact remained that there was now a 2-foot-high, 3-foot-wide landscaped median directly across my driveway entrance, making it physically impossible for me to drive in or out. I called a rideshare to get to my client meeting, which cost me $45 round trip. During the meeting, I found it hard to concentrate. My phone sat on the table next to my notepad, and I kept glancing at it, waiting for a call from Patricia Whitmore or someone else from the HOA board. The call came at 4:15. Just as I was walking back into my house, the number showed up as the HOA office. "Mr. Quinn, this is Patricia Whitmore, HOA president. I understand you have some concerns about our beautification project." Her tone was clipped and formal, with an undercurrent of irritation that immediately put me on edge. "Yes, thank you for calling back. The median installation has completely blocked my driveway. I can't get my car out. The project was approved unanimously by the board after extensive planning. We sent notice to all residents 6 weeks ago about the upcoming improvements." I pulled up my email and searched for any communication from the HOA. I found the notice she was referring to, a brief message with the subject line, "Community Beautification Initiative." I opened it and read through the vague description of enhanced landscaping features along Saguaro Drive and neighboring streets. There was no mention of medians, no specific locations, and certainly no indication that anyone's driveway access would be affected. "The notice didn't say anything about blocking driveways," I said, trying to keep my voice level. "The plans were available for review at the HOA office for anyone interested in seeing the details. It's not our responsibility to hand-deliver information to every resident who can't be bothered to stay informed." "Mrs. Whitmore, with all due respect, blocking someone's driveway is not a minor detail. This is my primary access to my property. According to Section 12 of the bylaws, homeowners are guaranteed reasonable access. I'm familiar with our bylaws, Mr. Quinn. The median does not block your access. You still have full access to your front door via the sidewalk. I'm talking about vehicle access. I have a car. I need to use my driveway. Perhaps you should have attended the board meetings where this was discussed. We had 3 separate sessions where residents could voice concerns. You didn't attend any of them." She had me there. I had never attended an HOA meeting. When I bought the house, I had promised myself I would stay involved in community affairs, but work always got in the way. The meetings were held on the 3rd Thursday of every month at 7, right when I usually had dinner with my girlfriend. Even so, I pressed on. "This seems like a clear violation of my property rights. I'm requesting that the median be modified to include a break at my driveway. The aesthetic integrity of the project requires continuous landscaping. Creating gaps would undermine the entire purpose. I'm sorry you're inconvenienced, Mr. Quinn, but the needs of the community take precedence over individual preferences. This isn't about preferences, it's about basic access to my property. If you're truly concerned, you're welcome to submit a formal appeal to be heard at next month's board meeting. Until then, the project moves forward as planned. Have a good evening." She hung up before I could respond. I stood in my living room, phone still pressed to my ear, listening to dead air and feeling my blood pressure rise. That evening, I did what any reasonable person in the modern age would do. I started researching. I looked up property law in Arizona, HOA regulations, and similar cases where associations had overstepped their authority. What I discovered gave me hope. Arizona law was actually quite protective of homeowner rights, particularly when it came to property access. There were multiple cases where courts had ruled against HOAs that had restricted owners' reasonable use of their property. I also learned something interesting about my specific property. When I pulled up the original deed and plat map, I noticed that my lot was slightly different from the others on the street. My house had been one of the first built in the Sunset Ridge development back in 1987, before the HOA had even been established. The deed included a specific easement clause that guaranteed vehicular access from the main road to my garage. This easement was recorded with the county and predated the HOA's authority. My heart started beating faster as I read through the legal language. If I was understanding this correctly, the HOA did not have the right to block my easement, regardless of what their bylaws said. The easement was a property right that ran with the land itself. I spent the next 2 hours making copies of every relevant document I could find. The original deed, the easement agreement, the plat map, the HOA bylaws, and the Arizona statutes related to property access. I compiled everything into a detailed folder and drafted a formal letter to the HOA board. The letter was polite but firm. I explained that the median violated my recorded easement rights, cited the specific legal precedents I had found, and requested that the median be modified within 7 days to restore my access. I also mentioned that if the issue was not resolved, I would be forced to seek legal remedies. I sent the letter via certified mail the next morning and emailed a copy to every board member whose email address I could find. Then I called my insurance company to see if my homeowner's policy included any legal coverage for disputes like this. The agent told me I had up to $50,000 in coverage for property rights issues, subject to a $500 deductible. Armed with that information, I also called a real estate attorney whose name I found through the Arizona Bar Association's referral service. Her name was Jennifer Sullivan, and when I explained my situation, she sounded immediately interested. They blocked your driveway with a landscaping median, and you have a recorded easement? She asked for clarification. That's right. The easement dates back to 1987, before the HOA even existed. That's pretty cut and dry then. They can't block a recorded easement. Do you have copies of all the documentation? I do. I can send everything over this afternoon. Please do. I'll review it and give you a call tomorrow. In the meantime, document everything. Take photos. Keep records of any expenses you incur because of this. Save all communication with the HOA. I felt validated for the first time since this nightmare had started. I spent the rest of the day photographing the median from every angle, documenting exactly how it blocked my driveway, and creating a detailed timeline of events. 3 days passed with no response from the HOA. The landscaping crew finished their work, and I had to admit the median looked professionally done. My neighbors seemed to love it. I heard several of them commenting on how much nicer the street looked. One elderly woman who lived 2 houses down even stopped by to tell me how much the new landscaping had improved her view. I just wish I could actually use my driveway to enjoy the view, I replied, perhaps a bit more sharply than necessary. She looked confused. What do you mean? I pointed to the median cutting across my driveway entrance. I can't get my car in or out. Her expression shifted to shock. Oh my goodness, I hadn't noticed. That's terrible. Have you talked to Patricia about it? I've tried. She says the project was approved and that's that. The woman, whose name was Doris, shook her head. Patricia can be very stubborn once she's made up her mind about something. She was the one who pushed hardest for this landscape project, said it would increase all our property values. This was useful information. Was there much discussion at the board meetings about it? Oh, there was plenty of discussion about the cost and the design, but I don't recall anyone mentioning it would block access to anyone's driveway. I'm sure if people had known, they would have objected. I thanked Doris for the information and made a mental note to document our conversation. It supported my position that residents had not been properly informed about the project's impact. On the 4th day, I received a response from the HOA. It came in the form of a formal letter signed by Patricia Whitmore and 2 other board members. The letter acknowledged receipt of my concerns and stated that the board had reviewed my claims regarding the easement. However, they maintained that the median did not violate my rights because I still had pedestrian access to my property. They argued that the easement guaranteed access, but did not specifically guarantee unobstructed vehicular access at all times. It was a ridiculous argument, and they had to know it. An easement for vehicular access that did not actually allow vehicles to pass was meaningless. But it had told me something important. They were not going to back down willingly. I forwarded the letter to Jennifer Sullivan. She called me within an hour. This is honestly one of the more absurd HOA disputes I've seen, and I've seen quite a few, she said. Their argument has no legal merit. A vehicular easement that doesn't permit vehicles is like saying you have a right to water, but they can prevent water from reaching you. So what are my options? We can file for a temporary restraining order and an injunction requiring them to restore your access while the dispute is resolved. Given the clear violation of your easement rights, I'm confident a judge would grant it. The question is whether you want to go that route. How much are we talking in legal fees? For the TRO and injunction, probably around $3,000 to start. If they fight it and it goes to a full hearing, could be another $2,000 to $5,000. But honestly, once we file, I suspect they'll settle. No HOA wants the publicity of a lawsuit over something this egregious. I thought about it. $3,000 was not nothing, but I had savings, and my insurance would cover most of it after the deductible. More importantly, I was angry now. This was not just about the driveway anymore. It was about an HOA that thought it could ignore property rights and bully homeowners into submission. Let's do it, I said. Great. I'll draft the paperwork today. We should be able to file by tomorrow afternoon. That night, I could not sleep. I kept running through scenarios in my head, imagining how the HOA would react, whether my neighbors would support me or view me as a troublemaker. I had always tried to be a good neighbor, keeping my lawn maintained, not making noise, waving hello when I saw people. Now I was about to sue the organization that governed our entire community. Jennifer filed the paperwork on Friday afternoon. According to the court procedures, the HOA would be served on Monday, and we would have a hearing within 10 days. Over the weekend, I prepared myself for the fallout. It came faster than I expected. On Sunday evening, I received an email from Patricia Whitmore. The subject line read lawsuit, and the tone was frigid. Mr. Quinn, I have been informed that you have filed a lawsuit against the Sunset Ridge HOA. This is a deeply disappointing and hostile action that will cost our community thousands of dollars in legal fees. Rather than working with us to find a reasonable solution, you have chosen litigation. Please be advised that the board will defend itself vigorously against your baseless claims. Furthermore, we will be conducting a thorough inspection of your property for any violations of HOA guidelines, as is our right under the covenants. The threat was clear. They were going to retaliate by looking for any possible violation they could use against me. I forwarded the email to Jennifer. This is actually helpful, she said when she called me back. Retaliatory enforcement is prohibited under Arizona law. If they suddenly start citing you for violations after you filed suit, it supports your case that they're acting in bad faith. So I shouldn't worry about it? Just keep your property in good order and document everything. If they cite you for something ridiculous, it'll only make them look worse to the judge. The following Tuesday, exactly 1 week after the median had been installed, I received my first violation notice from the HOA. According to the letter, my mailbox was not the approved shade of black as specified in the community guidelines. It needed to be repainted within 14 days, or I would face a fine of $100 per day. I walked outside and looked at my mailbox. It was black. It had always been black. I took photos from multiple angles in different lighting conditions. Then I walked down the street and photographed every other mailbox. They were all slightly different shades of black, varying based on age and weathering. None of them were exactly identical. The second violation notice came on Thursday. This one claimed that my lawn exceeded the maximum allowed height of 3 inches. I had just mowed it 2 days earlier. I grabbed a tape measure and went outside, measuring the grass in multiple spots. The tallest blade I could find was 2 3/4 inches. I documented everything with photos and timestamps, then sent it all to Jennifer. She was building quite a file. The hearing for the temporary restraining order was scheduled for the following Wednesday at 2 in the afternoon. Jennifer told me to dress professionally and to bring all my documentation. She would handle most of the talking, but the judge might have questions for me directly. I took the day off work and put on my best suit. The courthouse in downtown Phoenix was busy, with people moving through metal detectors and attorneys huddled in corners discussing cases. Jennifer met me in the lobby, looking confident in a navy pantsuit with her hair pulled back professionally. "Ready?" she asked. "As I'll ever be." We made our way to the courtroom, a smaller hearing room on the 3rd floor. The HOA was represented by a lawyer named Donald Chen, who arrived with Patricia Whitmore and another board member I did not recognize. Patricia gave me a look that could have frozen water. The judge, a woman in her 50s named Margaret Rodriguez, called the hearing to order promptly at 2. Jennifer presented our case, walking through the easement documentation, the timeline of events, and the legal precedents supporting our position. She was clear, organized, and persuasive. Your Honor, this is a straightforward case of an HOA violating a recorded property easement. Mr. Quinn has a legal right to vehicular access as documented in his deed and filed with the county in 1987. The HOA's installation of a landscape median directly across his driveway entrance makes it physically impossible for him to exercise that right. Under Arizona law, an easement cannot be blocked or substantially interfered with by another party, even if that party has general authority over the area in question. Donald Chen stood up for his. Your Honor, the HOA maintains that Mr. Quinn still has access to his property via the sidewalk and front entrance. The easement in question does not specifically mandate that his driveway remain unobstructed at all times. The HOA has broad authority to make improvements to common areas, which includes the landscaping along the street. Mr. Quinn was notified of this project and had opportunities to voice concerns before construction began. Judge Rodriguez looked over the documents in front of her, her expression neutral. Mr. Chen, am I understanding correctly that your position is the vehicular easement doesn't actually guarantee vehicle access? That's an oversimplification, Your Honor. We're saying that the easement must be balanced against the HOA's authority to manage common areas for the benefit of all residents. And how exactly is Mr. Quinn supposed to get his vehicle to his garage? The median is decorative landscaping, Your Honor. With care, a vehicle could potentially navigate around it, or have you seen photographs of this median? The judge interrupted, holding up one of the pictures Jennifer had submitted. This is a raised landscape feature with river rock and plants, Mr. Chen. Could you drive your car over this without damaging both the landscaping and your vehicle? Chen hesitated. It's not ideal, Your Honor, but it's not ideal, it's impossible. That's the point. She turned to Jennifer. Do you have the original easement documentation? Jennifer pulled out the certified copy we had obtained from the county recorder's office. Judge Rodriguez spent several minutes reviewing it, asking a few clarifying questions about the dates and the specific language used. Finally, she set down the papers and looked at both attorneys. I'm granting the temporary restraining order. The HOA is prohibited from maintaining the landscape median in a configuration that blocks Mr. Quinn's driveway access. The median must be modified to allow full vehicular access within 7 days. We'll schedule a full hearing on the underlying issues for next month, but in the meantime, Mr. Quinn's access must be restored. I felt relief wash over me. Patricia Whitmore's face turned red, and she leaned over to whisper urgently to Donald Chen. He nodded and stood up. Your Honor, if I may request a brief stay to allow the HOA board to discuss the logistics. 7 days, Mr. Chen. The order is effective immediately. Court was adjourned, and Jennifer turned to me with a satisfied smile. That went about as well as it could have. Thank you, I said, feeling like a weight had been lifted off my shoulders. We walked out of the courtroom, but Patricia intercepted us in the hallway. Up close, I could see she was probably in her late 50s, with carefully styled blonde hair and expensive jewelry that seemed out of place for a routine court appearance. I hope you're proud of yourself, she said to me, ignoring Jennifer entirely. Do you have any idea how much this is going to cost the HOA? That money comes from your neighbor's dues, you know. Everyone in this community is going to pay for your selfishness. Jennifer stepped between us smoothly. Mrs. Whitmore, you should direct all communication through your attorney. And for the record, this situation could have been avoided entirely if the HOA had simply not blocked my client's legal easement in the first place. Patricia's eyes flashed. This isn't over. We'll see what the full hearing brings. Looking forward to it, Jennifer replied calmly. As we walked away, I asked Jennifer, is she right? Will this cost the other homeowners money? Probably, but that's on the HOA board, not on you. They made the decision to block your easement and then double down instead of fixing it when you pointed out the problem. You have every right to protect your property interests. Over the next week, I watched as the landscaping crew returned to my house. This time, they carefully removed a section of the median directly in line with my driveway, creating a gap about 15 feet wide. They installed small decorative barriers on either side to delineate where the median resumed, but my access was fully restored. I pulled my car out of the garage for the first time in 2 weeks, feeling an absurd sense of triumph at such a simple act. Several neighbors came out to watch, and reactions were mixed. Some, like Doris, were supportive and glad I had stood up for my rights. Others seemed annoyed that I had disrupted the uniform appearance of the new landscaping. I received another email from Patricia that evening. This one informed me that the HOA would be countersuing for the cost of modifying the median, attorney fees, and damages to community cohesion. Jennifer laughed when I forwarded it to her. "Let them try," she said. "They don't have a leg to stand on. If anything, you could countersue for your attorney fees and the costs you incurred while your access was blocked." Should I? Let's see how the full hearing goes, but keep track of everything you've spent. The ride shares, your attorney fees, any other expenses directly related to this situation. I started a detailed spreadsheet documenting every dollar I had spent because of the blocked driveway. The ride shares, parking fees from having to leave my car at a friend's house for a few days, and Jennifer's legal bills. It was approaching $4,000 and climbing. The full hearing was scheduled for 6 weeks out, which gave me time to prepare but also time to worry. In the interim, I received 2 more violation notices from the HOA. One claimed that I had placed my trash cans out too early before collection day, even though I had put them out at the exact same time I always did. The other said that my front porch light was burned out and needed to be replaced, which was true, but I had only learned about it the day before when the bulb died. I fixed both issues immediately and documented everything with time-stamped photos and receipts. Jennifer assured me that this pattern of petty enforcement was actually strengthening our case. "It shows retaliatory behavior," she explained. "They never bothered you about any of this stuff before you filed suit, right?" "Never. I didn't even know I had an HOA until I bought the house, and they've pretty much left me alone for 3 years." Perfect. That's exactly the narrative we want to establish. As the hearing date approached, I learned more about Patricia Whitmore and the HOA board. Through conversations with neighbors and some discreet research, I discovered that Patricia had been HOA president for 7 years, running essentially unopposed because few people wanted the position. She had a reputation for being controlling and vindictive, with several residents mentioning past disputes where she had made people's lives difficult if they crossed her. One neighbor, a man named Robert who lived at the end of my street, told me about his own run-in with Patricia 2 years earlier. He had wanted to install solar panels on his roof, which the HOA guidelines technically allowed with board approval. Patricia had denied his application 3 times for increasingly trivial reasons before he finally gave up. She didn't want solar panels in the neighborhood because she thought they looked ugly, Robert explained. "Never mind that they're good for the environment and would save me money. She just didn't like them, so that was that." "Why didn't you fight it?" I asked. "Honestly, I didn't have the energy. I admire what you're doing, standing up to her. Someone needs to." This conversation gave me an idea. I started talking to more neighbors, asking about their experiences with the HOA. What I discovered was eye-opening. Patricia had a history of denying reasonable requests, selectively enforcing rules against people she did not like, and generally running the HOA like her personal fiefdom. I brought this information to Jennifer. "Is any of this relevant to our case?" It could be. It establishes a pattern of behavior. Do any of these people would be willing to provide sworn statements or testify? I reached out to Robert and a few others. Most were hesitant to get involved directly, worried about becoming Patricia's next target. But Robert and one other homeowner, a woman named Lisa, agreed to provide written statements about their experiences with the HOA board. The night before the full hearing, I barely slept. I reviewed all the documents one more time, making sure I understood every detail. Jennifer had prepared me for the kinds of questions I might face, and we had rehearsed my testimony several times. Still, I felt nervous. The hearing was held in the same courthouse, but in a larger courtroom this time. Judge Rodriguez presided again, which Jennifer said was good news since she was already familiar with the case. The HOA's attorney, Donald Chen, had brought what looked like a substantial amount of paperwork stacked in neat folders on his table. Jennifer presented our case first, building on the foundation she had established during the TRO hearing. She walked through the easement rights in detail, showed photographs and diagrams of how the median blocked access, and presented evidence of the HOA's retaliatory behavior through the violation notices. Your Honor, what we have here is a clear-cut case of an HOA overstepping its authority and then punishing a homeowner for asserting his legal rights. The easement in question is unambiguous. It grants Mr. Quinn vehicular access from the public road to his garage. The HOA's median made that access physically impossible. When Mr. Quinn rightfully objected, the HOA responded not by correcting their error, but by targeting him with petty violations that they had never enforced before. She called me to testify. I walked to the witness stand, was sworn in, and tried to keep my voice steady as Jennifer asked me questions about the timeline of events, my attempts to resolve the issue before filing suit, and the violation notices I had received. Mr. Quinn, in the 3 years you lived at this property before the median was installed, how many violation notices did you receive from the HOA? None. And after you filed this lawsuit, 4 and 6 weeks. Can you describe the nature of these violations? I went through each one, explaining how trivial they were and how I had never been cited for similar issues in the past. Judge Rodriguez took notes as I spoke. Donald Chen cross-examined me, trying to suggest that I had simply been lax about maintaining my property and the violations were legitimate. But I had my documentation ready, including photos showing that my mailbox was the same shade as others on the street and that my grass had been well within the height limits. Mr. Quinn, isn't it true that you never attended any HOA meetings where the median project was discussed? That's correct. So you were not engaged with the community planning process. I work full-time and the meetings conflicted with my schedule. But I did receive the email notice about the beautification project. It didn't mention that anyone's driveway would be blocked. The detailed plans were available at the HOA office for review during business hours when I was at work. And again, nothing in the notice suggested that reviewing the detailed plans was necessary to protect my property rights. Chen moved on to questions about the easement, trying to argue that it was ambiguous or that the HOA's authority superseded it. But Jennifer had prepared me well, and I stuck to the facts. The easement was recorded, it was clear, and it predated the HOA's existence. After my testimony, Jennifer called an expert witness, a real estate attorney who specialized in easement law. He testified that vehicular easements were well established in Arizona law and that blocking such an easement was a clear violation of property rights. The HOA's case relied heavily on their authority under the CC&Rs to make improvements to common areas. They brought their own expert, a community association manager, who testified about the importance of HOA governance and the need to balance individual interests against community benefits. Patricia Whitmore also testified. She was poised and confident, describing the median project as a carefully planned initiative to improve property values. When Jennifer cross-examined her, though, cracks started to show. Mrs. Whitmore, when the board approved this project, did anyone raise concerns about blocking Mr. Quinn's driveway? The plans clearly showed where the median would be installed. It was Mr. Quinn's responsibility to review them if he had concerns. That's not what I asked. Did anyone on the board specifically discuss the fact that the median would block his driveway? Patricia hesitated. It may have been mentioned. May have been. You're the president. You ran these meetings. Was it discussed or not? I don't recall the specific details of every discussion. Jennifer pulled out meeting minutes that we had subpoenaed. According to these official minutes from the board meeting where the project was approved, there's no mention of any discussion about driveway access. In fact, the entire discussion of the median project took less than 15 minutes. Is that accurate? Patricia's jaw tightened. We had already discussed it extensively in previous meetings. But there's no record of those discussions in any of the previous meeting minutes either, is there? Not every detail makes it into the minutes. Judge Rodriguez intervened. Mrs. Whitmore, it seems like a fairly important detail if you're about to block a homeowner's primary vehicle access. Why wasn't this flagged as a potential issue? We believe that the overall benefit to the community outweighed any individual inconvenience. Did you consult with an attorney about whether you had the right to block a recorded easement? Patricia shifted in her seat. We didn't feel it was necessary. The board has broad discretion over landscaping in common areas. So that's a no? Correct, Your Honor. We did not consult an attorney beforehand. This was clearly damaging to their case. Jennifer pressed further, asking about the retaliatory violations. Mrs. Whitmore, before Mr. Quinn filed this lawsuit, had you ever cited him for HOA violations? I don't personally handle every violation notice. But as president, you're aware of enforcement actions taken against homeowners, correct? Generally, yes. So I'll ask again, before the lawsuit, had Mr. Quinn been cited for violations? Not to my knowledge. And after the lawsuit was filed, he received 4 violation notices in 6 weeks. Don't you find that timing suspicious? We conduct regular property inspections. If violations were found, they needed to be addressed. Regular inspections? Can you provide records showing when you last conducted similar inspections of other properties on Saguaro Drive? Patricia could not. Jennifer had already subpoenaed the HOA's enforcement records, and they showed that no other homes on my street had been inspected or cited during that same 6-week period. The hearing lasted most of the day. By the time closing arguments were complete, it was after 4 in the afternoon. Judge Rodriguez said she would take the matter under advisement and issue a written ruling within 2 weeks. Walking out of the courthouse, I felt drained but cautiously optimistic. Jennifer seemed pleased with how things had gone. I think we made a strong case, she said. Chen couldn't effectively defend the easement violation, and Patricia's testimony about the retaliatory enforcement was pretty damning. What happens now? We wait. The judge will review everything and issue her decision. In the meantime, your access is still protected by the TRO, so they can't block your driveway again. The 2 weeks of waiting were agonizing. I threw myself into work, trying not to constantly check my email for updates. I had become something of a minor celebrity in the neighborhood, with people stopping me to ask about the case. Opinion remained divided. Some residents supported me and were glad someone was finally standing up to Patricia. Others thought I was being selfish and hurting the community over a minor inconvenience. One evening, I came home to find a note taped to my front door. It was handwritten, anonymous, and hostile. Hope you're happy ruining our neighborhood. No one wants you here. Move. I felt a chill run through me. I took the note inside and photographed it, then filed it away with all my other documentation. I did not know if it was from Patricia or just someone who agreed with her, but it was unsettling either way. Finally, 12 days after the hearing, Jennifer called. We got the ruling. You're going to want to sit down for this. My heart pounded. Good news or bad? Very good. The judge ruled in our favor on every point. She found that the HOA violated your easement rights, that their authority over common areas doesn't extend to blocking recorded easements, and that the pattern of violations after you filed suit constituted retaliatory enforcement, which is illegal under Arizona law. Oh my God. It gets better. She's ordering the HOA to pay your attorney fees and costs, plus $5,000 in damages for the retaliatory enforcement. And she's issued a permanent injunction preventing them from blocking your easement in the future. I actually felt tears spring to my eyes. Jennifer, I don't know what to say. Thank you. You're very welcome. You stood up for your rights, and you were absolutely in the right. This is why I became a lawyer. The official ruling arrived in my email an hour later. It was a comprehensive 17-page document that methodically dismantled every argument the HOA had made. Judge Rodriguez's writing was clear and forceful, particularly when addressing the retaliatory enforcement. The pattern of violations issued to the plaintiff immediately following his lawsuit is highly suspicious and suggests improper motives. An HOA cannot use its enforcement power as a weapon against homeowners who assert their legal rights. Such behavior undermines the entire purpose of community governance and creates a chilling effect that prevents residents from advocating for themselves. I read the entire ruling twice, savoring every word. Then I forwarded it to several neighbors who had supported me, including Robert and Doris. The fallout was immediate. Within 24 hours, there was an emergency HOA meeting called. I was not invited, but Robert attended and filled me in afterward. It was absolute chaos, he told me. People were furious, mostly at Patricia. Someone calculated that between the attorney fees, your damages, and the cost of modifying the median, this whole thing cost the HOA over $30,000. Annual dues are probably going to increase to cover it. How did Patricia respond? She tried to blame you, said you were unreasonable and litigious. But a lot of people weren't buying it. Someone pointed out that if the board had just consulted an attorney before blocking your driveway, or if they had backed down when you first complained, none of this would have happened. There were calls for her to resign. Did she? Not yet. But there's a petition circulating to call a special election for the board. I think her days as president are numbered. Over the next few weeks, the neighborhood dynamics shifted. More people started questioning HOA decisions and attending meetings. The rubber stamp approval process that Patricia had enjoyed for years was over. People were paying attention now. I received a formal letter from the HOA's attorney indicating that they would not appeal the ruling and would comply with all court orders. A check for my attorney fees, costs, and damages arrived a week later. But there was still something that bothered me. In all my research and document review, I had discovered something interesting about the HOA's common areas and the land where the median had been installed. According to the original plat map from when the development was created, the strip of land along the street where the median sat was actually supposed to be maintained as a public easement for utilities and access. It was not technically HOA property at all. This raised an interesting question. If the HOA did not actually own that land, did they have any right to install the median there in the first place, even setting aside the issue with my driveway? I brought this to Jennifer's attention. She reviewed the plat maps and the HOA's founding documents. "You're right," she said, sounding surprised. "This land is designated as a public easement. The HOA has been treating it as their property, but they don't actually have title to it. The city or county would have authority over this area. So the median might be illegal regardless of whether it blocks my driveway? Potentially. Though since the case is already resolved, I'm not sure there's much benefit to pursuing it further, unless you want to make sure they can't put the median back after the current situation." I thought about it. Part of me wanted to let sleeping dogs lie. I had won my case, my access was restored, and Patricia's reign over the HOA was crumbling. But another part of me wanted to make absolutely sure this could never happen again. Not just to me, but to anyone else in the community. What would it take to confirm the status of that land, I asked. We'd need to file a quiet title action, or get clarification from the county. It could be expensive and time-consuming. But if we're right and that land is public easement, then the HOA shouldn't be maintaining a median there at all, should they? Correct. It would need to be removed, or they'd need to get proper permission from the relevant government entity. An idea was forming in my mind. What if I brought this to the county's attention directly, not as a lawsuit, just as a concerned citizen pointing out a potential encroachment on public land? Jennifer smiled. That's actually pretty clever. No cost to you, and if the county decides to pursue it, the HOA would have to deal with them instead of you. I drafted a detailed letter to the county planning department, including copies of the plat map, photographs of the median, and a polite inquiry about whether the HOA had obtained proper permits for improvements on public easement land. I cited the specific parcel numbers and legal descriptions to make it easy for them to verify. 3 weeks later, I received a response from a county code enforcement officer named Marcus Thompson. He thanked me for bringing the issue to their attention and confirmed that the land in question was indeed designated as public utility easement. The county had no record of the HOA requesting or receiving permission to install permanent landscaping in that area. We will be reaching out to the Sunset Ridge HOA to discuss removal of the unpermitted improvements or pursuing proper authorization through our Public Works Department, the letter stated. I forwarded the letter to Jennifer, who sent back a simple reply, "Nicely done." The county's involvement added a whole new dimension to the situation. Patricia and the HOA board now had to deal not just with the fallout from losing our lawsuit, but also with county regulations they had apparently ignored. I learned through the neighborhood grapevine that the county had given the HOA 90 days to either obtain proper permits for the median or remove it entirely. The permit process would require public hearings, environmental review, and significant fees. Removal would be expensive and embarrassing. The HOA board, now under intense pressure from residents angry about increased dues and legal problems, chose to remove the median entirely. The same landscaping crew that had installed it came back and tore it all out, returning the street to its original configuration. Some neighbors were disappointed. They had genuinely liked the aesthetic improvement. But most people seemed relieved that the drama was over and that dues would not need to increase further to cover more legal expenses. 2 months after the judge's ruling, there was a special election for the HOA board. Patricia Whitmore chose not to run for re-election, announcing that she was stepping down to spend more time with family. 3 new board members were elected, including Robert, who ran on a platform of transparency and reasonable governance. The first thing the new board did was revise the HOA's enforcement policies to prevent retaliatory actions and ensure consistent application of rules. They also implemented a new review process for major projects that required direct notification to any homeowners who might be specifically affected. Robert stopped by my house a few weeks after taking office. "I wanted to thank you," he said. "What you did standing up to Patricia and the old board, it opened a lot of people's eyes. We've got a chance now to actually make this HOA work the way it's supposed to, for the community instead of for one person's ego." "I'm glad something good came out of it," I said. "To be honest, I just wanted to be able to park in my own garage." He laughed. "Sometimes that's how change starts. One person saying this isn't right and refusing to back down." Life in Sunset Ridge gradually returned to normal, or rather, to a new normal that was actually an improvement. The new board was responsive to concerns, transparent about decisions, and focused on genuine community improvement rather than power trips. Dues stabilized and even decreased slightly as the board negotiated better rates with service providers. I never received another violation notice for trivial matters. When I eventually did need to replace my fence a year later, the approval process was straightforward and reasonable. Patricia Whitmore sold her house and moved away about 6 months after the election. I never spoke to her again after the court hearing. I heard through neighbors that she had joined the board of another HOA in a different part of Phoenix, which made me feel sorry for those residents, but there was nothing I could do about that. The whole experience taught me several valuable lessons. First, that property rights matter and are worth defending, even when it seems easier to just go along. Second, that bullies, whether individuals or institutions, often back down when confronted with determination and facts. And third, that HOAs can be beneficial community organizations when run by reasonable people with good intentions, but can become nightmares when controlled by petty tyrants. I also learned that I was not alone in my frustration with HOA overreach. In the months after my case, several news outlets picked up the story. I did a few interviews, and my case was cited in articles about HOA reform. I heard from homeowners across the country who had their own horror stories about associations gone rogue. Some people suggested I should run for the HOA board myself, but I declined. I had no desire for that kind of responsibility or involvement. I was content to be an informed, engaged member of the community without taking on a leadership role. Robert and the other new board members were doing a fine job without me. What I did do was keep all my documentation from the case, organized and easily accessible. I figured if the issue ever came up again, or if another homeowner in the community faced similar problems, I could share my experience and help them navigate the process. About a year after the court ruling, I was doing some routine maintenance on my property when I noticed something interesting. The deed that had saved my case, with its recorded easement from 1987, was actually even more significant than I had initially realized. When I looked at it more carefully, I noticed that it contained specific language about the development plans for Sunset Ridge. According to the deed, when the first houses were built in this area, including mine, the developer had made certain commitments about access roads, common areas, and utilities. When the HOA was formed a few years later, it should have incorporated and honored those commitments, but somewhere along the way, they had been forgotten or ignored. I brought this to the attention of the new HO board. Robert and the other members were very interested, and they commissioned a legal review of the founding documents to make sure the HOA was properly aligned with the original development agreements. That review turned up several other issues where the HOA had drifted from its original charter. None as dramatic as blocking someone's driveway, but several policies that were inconsistent with what homeowners had originally been promised. The board worked through these systematically, making corrections and updating policies to ensure compliance. It was satisfying to see the organization genuinely improve. The HOA went from being a source of frustration and conflict to actually serving its intended purpose, maintaining common areas, organizing community events, and handling necessary administrative functions without being heavy-handed or arbitrary. My relationship with my neighbors also evolved. Some people remained distant, perhaps still viewing me as someone who had caused trouble. But many others became friendlier, stopping to chat when we crossed paths, inviting me to barbecues and block parties. I was no longer just the quiet guy who kept to himself. I was someone who had stood up for principle, and that earned a certain respect. There were moments of unexpected humor, too. One day I came home to find a small gift basket on my doorstep with a note that read, "Thank you for having the guts to fight back. Patricia cited me for having the wrong color roses 3 years ago. I've been waiting for someone to take her down. Enjoy the wine." It was unsigned, but the handwriting looked like it might have been from Helen, a woman 3 houses down who had always seemed vaguely annoyed whenever Patricia was mentioned. The financial aspect of the case worked out better than I had hoped. The HOA's payment covered all my attorney fees and costs, plus the $5,000 in damages. After reimbursing my insurance company for what they had covered, I actually came out slightly ahead. I used the extra money to upgrade my garage door opener and install a security camera system, figuring it was fitting that the HOA had inadvertently funded improvements to the very driveway they had tried to block. Jennifer Sullivan and I stayed in touch. She sent me occasional updates about other HOA cases she was handling, some of which made my situation look tame by comparison. Apparently, there was a whole world of these disputes out there, with associations doing everything from banning American flags to restricting what color cars could be parked in driveways. It made me grateful that my own situation had been relatively straightforward, legally speaking. One case she told me about involved an HOA that tried to foreclose on a homeowner's property over less than $1,000 in disputed fines. Another involved an association that banned children from playing in their own front yards because it was deemed disruptive to the aesthetic. Hearing these stories reinforced my belief that HOA reform was needed at a broader policy level, though I was not personally inclined to become an activist about it. What I did do was share my story when asked. I gave a presentation at a local homeowner rights workshop, walking through the steps I had taken and the documentation that had been crucial to my case. Several attendees approached me afterward with their own situations asking for advice. I was not a lawyer and could not give legal advice, but I could share my experience and encourage people to stand up for their rights while following proper procedures. The presentation led to a request to write an article for a homeowner advocacy website. I spent several evenings drafting a detailed account of my experience, focusing on the practical steps I had taken, documenting everything, researching the law, seeking professional help, and staying calm under pressure. The article got thousands of views and dozens of comments from people sharing their own HOA nightmares. Through all of this, I maintained my normal life and work routine. The HOA situation had been all-consuming for a few months, but it was ultimately just one chapter, not my whole story. I got a promotion at work, started dating someone new, and generally moved forward with my life. But the experience changed me in subtle ways. I was more aware of my rights and more willing to question authority when it seemed to be overreaching. I paid attention to local government meetings and community issues in a way I had not before. I became the kind of engaged citizen I had always thought I should be but had never quite managed. 2 years after the median incident, Sunset Ridge was a genuinely pleasant place to live. The HOA functioned smoothly under reasonable leadership. The neighborhood looked well-maintained without being oppressively uniform. People actually knew their neighbors and looked out for each other. At a community barbecue that summer, I was standing by the grill with Robert and a few other neighbors when someone mentioned the infamous median saga. Everyone laughed about it now, though it had been anything but funny at the time. Remember when Patricia tried to argue that a vehicle easement did not mean you could actually drive a vehicle on it? Robert said, shaking his head. I still can't believe she thought that would fly in court. The look on her face when the judge basically called it ridiculous, I added. That was a good day. You know what the best part is? Asked Tom, another neighbor who had served on the old board but distanced himself from Patricia's leadership. Property values actually did go up after all that. Not because of landscaping, but because people want to live in a neighborhood with a reasonable HOA. Word got around that Sunset Ridge cleaned house and got its act together. It was true. I had noticed more houses selling quickly when they hit the market, often with multiple offers. Real estate agents were actually using professionally managed HOA as a selling point, which would have been laughable during Patricia's reign. As the sun set over the Arizona desert that evening, casting long shadows across the street where the median had briefly existed, I felt genuinely content. My driveway was clear and accessible. My community was well managed and harmonious. And I had learned that standing up for your rights, even when it is difficult and uncomfortable, can lead to positive change, not just for yourself, but for everyone around you. The whole experience could be summed up pretty simply. An HOA blocked my driveway with a landscaping median, thinking their authority was absolute. I blocked their overreach with my deed, property law, and a willingness to stand my ground. In the end, the law was clear, justice prevailed, and a community became better for it. Sometimes the most important battles are fought not over grand principles, but over simple things like being able to park in your own garage. And sometimes, one person refusing to accept unreasonable treatment can spark changes that benefit everyone. That is what happened in Sunset Ridge, and I was proud to have been the catalyst, even if all I really wanted was access to my driveway. Looking back, I could not help but appreciate the irony. Patricia Whitmore had tried to use her authority to diminish my property rights and make an example of anyone who dared to question the HOA's decisions. Instead, she lost her position, cost the association tens of thousands of dollars, and ultimately improved the community by forcing it to reckon with years of mismanagement. The median itself, which had been the source of so much conflict, was gone without a trace. The landscaping crew had done a thorough job of restoration, and you would never know there had been a dispute unless someone told you the story. But the impact of that dispute lingered in positive ways. Better governance, more engaged residents, and a community that had learned the value of accountability. I still live in that house on Saguaro Drive. My driveway remains gloriously unobstructed, and I never take for granted the simple act of pulling into my garage after a long day. Every time I do, I remember the battle it took to preserve that right, and I am grateful I had the resources, support, and determination to see it through. The story became something of a legend in HOA reform circles. I occasionally still get emails from people who read about the case or saw one of my interviews, asking for advice on their own situations. I always respond with the same basic message. Document everything, know your rights, do not be afraid to seek professional help, and never assume that an authority figure is acting within their proper bounds just because they claim to be. And if I have one piece of advice for anyone buying a home in an HOA community, it is this: read your CC&Rs carefully. Keep copies of all your property documents, including deed restrictions and easements, and pay attention to who is running your association. Good governance makes all the difference between a community asset and a neighborhood nightmare. As for Patricia Whitmore, I hope she learned something from the experience, though I somehow doubt it. People like that rarely do. But at least in Sunset Ridge, her legacy is not one of fear and arbitrary enforcement, but rather a cautionary tale about what happens when power goes unchecked and property rights are ignored. The blocked driveway incident taught me that home ownership is not just about having a place to live. It is about having rights that are worth defending, a community worth investing in, and sometimes the courage to stand up and say that something is wrong, even when it would be easier to stay silent. I found that courage, and it made all the difference.